don't know what we're doing, but I'm ready. If you're
Ready when you are, sir.
May it please the court, Bob McKenzie for the appellant. I'd like to reserve 5 minutes if I might.
You may.
It's an unfortunate fact of life that elderly people who need skilled nursing in these facilities get better care when family is prone to pop in and out. I know that from experience in my mother-in-law's situation. What Priscilla Edelman initially wanted to do was have her mother in Hillsborough County, where Priscilla lived, in order that when she had to be moved from the facility at Sarasota up to somewhere else, that she would be able to provide her with the extra care that a daughter can. Burton Boardman was managing because of his power of attorney, the residence or placement, if you will, of Bluma Boardman. And to him, because he lived in Connecticut, to him it's more like warehousing than it was to the daughter. It was a place because he was not around. So I submit to you that all the evidence in this case shows that the best interest of Bluma Boardman was the initial precipitating factor concerning the filing of these two petitions that were filed. It was uncontradicted in the trial court in the December 15th, 09 order dismissing the incapacity petition, said that the disagreement arose because of placement. Placement over in Menora Manor, which of course is not as convenient to Priscilla Edelman. Much easier and better for her, but moreover for the mother, for her to be able to visit her in Hillsborough County and take care of her needs. Barbara Johnson, who's the other daughter of Bluma, lived in Arizona. When this disagreement in 2007 arose, she picked up the phone and called the drafting attorney for the documents in question, Ralph Friedland, and wanted to know by what authority Burton was able to move Bluma to Menora Manor when the two daughters didn't think that she should be there. And then she was told about this power of attorney. The trial court found that Priscilla Edelman knew about the power of attorney, and that was established, and that was a factual finding of the trial court. There's no evidence that Priscilla Edelman or Barbara Johnson had possession of this power of attorney until 2007. So Priscilla Edelman went to the attorneys. They had this disagreement about the placement of Bluma, and the attorneys prepared companion petitions, as is the case, for a petition for incapacity and one for a petition.
Let me make sure I understand a key point that you've made. Is it in our record that we somehow, I thought I understood you to say that your client did not have knowledge that the appellant in this case was named power of attorney and a durable power of attorney, and at the time the lawsuit was filed to establish a guardianship, she was unaware of the power of attorney. Is that what I've understood you to say?
No.
Okay.
The trial court,
I misunderstood you. I'm sorry.
The trial court found that she knew that Burton had a power of attorney, but there was nothing in the record to show that Priscilla Edelman had a copy of it.
Okay. I just want to make sure I was clear on that.
So one of two things, the lawyers either...
Went on for 6 years. She knew about these documents for 6 years. And the brother managed the mother's affairs without objection?
I don't know to what extent if any, the document came up. I don't know if it came up, but the mother had been there since '01, and everything, was fine. She was visiting down there, they also had a condominium in Sarasota, and there's no indication that it even came up. But when it did come up, it came up in terms of this disagreement about the best place for Bluma's placement. So these companion petitions for incapacity and for guardianship, the attorneys drafted for Priscilla, and the guardianship petition said this: the proposed guardian, that is Priscilla, should be appointed because she lives closer to the ward than the ward's other children. She's in the best position to be able to care for the ward's needs, and she's the best person to look out for the best interest of the ward.
But the issue at the time of the filing of the petition to establish a guardianship was, did the petitioner have knowledge that there was a less restrictive means already in place? And what I understood from reading the record in this case and the court's order is that the petitioner had that actual knowledge that there already was in place a less restrictive means to address the problem, such as the trust that handled the money, which the brother was a trustee of, such as the power of attorney that we've talked about, that the brother basically had the power of attorney, and that the petitioner had actual knowledge of these things, according to the court's order, for a period of at least 6 years. So at the time of the filing of the guardianship, the court said it was done without good faith or in bad faith because there was knowledge that this was already in place and had been operating without argument or interruption for a 6-year period, and it only wasn't until this placement issue came up was there now a decision that maybe that this was not adequate or there were problems with it or things of that nature.
The court said that the power of attorney is likely, as an alternative to guardianship, is likely within the understanding of the average adult. And I submit that, and we touched on this, we dealt with this in the brief, that that's just not the case.
Well, if the money's all in trust, and there's a health care surrogate to make decisions about health care in place, which also was in the record, and that there is this durable family power of attorney, help me understand why a guardianship is better than those 3 things which have already been in place and been operating without complaint or interruption until this unfortunate placement dispute came up.
Well, first of all, you're assuming that...
I'm not assuming anything. I'm trying to understand it.
Well, the trial court said that there was knowledge of valid documents, okay?
Well, didn't she take the mother to one of the attorneys for a 4th modification?
Absolutely not. Absolutely not. And that's one of the reasons why all these delays, a lot of them occasioned by a trial judge, may have entered into the drafting of the order.
Aren't these all disputed issues of fact ultimately?
No.
Evidence supporting your position is evidence supporting what the trial court's ruling was? I mean, the trial court wasn't required to accept at face value that Ms. Edelman had no knowledge of alternative documents to a guardianship proceeding.
Well, to get back to the original thing that you asked, the evidence showed, yes, that Priscilla Edelman benefited from an amendment to the trust, which was 8 months after the questioned power of attorney date. And I really think that is what excited the trial judge about the whole matter. However, the evidence showed that the trial judge said that Priscilla Edelman took Bluma to the lawyer's office and had this done. Although it was done, and it did benefit Priscilla Edelman, that didn't happen. The documents were prepared, and Burton Boardman had Bluma sign them. It did modify the trust. But, you know, if there were a claim for civil damages or money damages or something like that, would Priscilla Edelman be stopped because she allowed this thing to happen after the contested date of the DPOA? Yes, she might be. But we're not talking about an estoppel for her to recover anything. We're talking about the best interest of the mother. And Priscilla Edelman, the bedrock fact here is that placement was always the precipitating factor here. In the petition for incapacity, okay, the allegation prepared by the lawyers, the allegation was made that she wasn't aware of sufficient, and that's a key word under the statute, or under the rule. She wasn't aware of sufficient alternatives to solve the problem. Well,
Well, let me ask you this. Was there a remedy that could have been sought if she believed the mother was not getting the best care possible, short of filing a new petition alleging there were no alternatives in place? Would she have gotten a declaratory judgment, for example, or something else?
You'd have to ask Fowler White that. She went there and she said,
I'll withdraw the question.
Yeah, and the problem was the placement of the mother. That was, she had the best interest of her mother.
I'm just saying the judge probably was infuriated based upon false allegations, and she had to weigh the allegata and the probata, and apparently it's not in the record as to what other remedies might have been available, but this was not the remedy that the judge found was appropriate.
Well, the only way attorneys' fees can be awarded is for bad faith filing of a petition for incapacity. Okay, and the reason for that's in the law is to discourage people from saying that someone is incompetent when they're not. And the several cases we have on the subject and the stigma that's attached to that, the several cases.
Well, there was no question. The judge said there's no question on incapacity in this case.
That's right.
The only question was when it might have occurred, and that
Well,
was a disputed issue of fact.
Well, what was disputed was a separate proceeding having to do with challenging the validity of the power of attorney, which was filed 2 months later. These are two different proceedings.
Right.
There's no doubt that there was a good faith filing and an effort, to take care of the mother's best interests, okay, and that she was incapacitated. That's really about all you need to know, because the reason for the statutory attorney's fees is to discourage a filing against someone who, for instance, in a couple of these cases, a wife trying to have her husband declared incompetent, they had dissolution proceedings and that sort of thing.
But the sole issue in this case was this placement. And your client lives in South Tampa, if I recall. Her mother had previously been in Sarasota.
Right.
And the move was to St. Petersburg, which was certainly not South Tampa, but it's better than Sarasota, probably, I'm guessing, I don't know. I didn't read any allegations that she was harmed in any of these facilities, and that the choice of the St. Pete facility was specifically because it was a Jewish facility, which was consistent with your client's mother's faith, and there was thought that she would benefit from that, and that it was otherwise a pretty good facility. Unless I've overlooked something in the record, I don't remember anybody taking a position that she got bad care at either one of these places.
Well, that was disputed insofar as the religious part is concerned. That was a disputed fact. I think that I hearken back to what I said to begin with. If it's better for the daughter to be able to visit, easier, more able to visit, that's going to be better for the mother, and that's what she
Well, it wasn't like her brother sent her to Missouri. I mean, it was, what are we talking, 10 miles?
Well, no, it's more than that.
15?
But
Anyway, it's not much.
it's certainly better for the mother, for her to be able to be closer in Tampa where she could visit more often, and she would be able to visit more easily and more often in Tampa to do that. But
Sir, you're at your 15 minutes. I just wanted to let you know you're free to use your time however you like.
all right, I'll
May it please the Court. Noelle McDonald, on behalf of the Appellate, Burton Boardman as respondent. I'd like to respond to the discussion which was just occurred. Appellate is asking the Court to reweigh the facts of the underlying trial. That's not the standard of review. That's not the issue before the Court today, and we resist the opportunity to go too far down that path. However, I do have to point out to the Court that
It might be hard for us to reweigh the facts of this hearing on fees because there was no transcript, so we have no idea what happened.
with all due respect, the only transcript that's missing is the transcript of the hearing on fees.
Right, the 4 hours
Yes.
fee hearing, right, we don't have that transcript, correct?
Yes, sir, that's
Okay,
absolutely correct.
That's what I thought I understood, right? This is
Notwithstanding-
what this case is all about, really, isn't it?
Well, the Court articulated a few minutes ago that this case was about the placement of Bloomer Boardman. And in fact, the trial court found that the seminal issue here was that Priscilla Edelman used the guardianship proceedings as an effort to wrest away from the proposed ward her thoughtful, dedicated, and written testamentary plan in order to gain control over the proposed ward and to gain control over the proposed ward's inter vivos trust during her lifetime. A situation that otherwise the appellee would not have standing to do unless she gained guardianship. And that initial motivation was a bad faith motivation and not a basis to ignore and abjectly inform the Court, not only by omission and failing to admit that there were advance directives, but by commission and affirmatively saying that there were not advance directives in her petition. From that very inception, the bad faith petition, everything that followed after that was triggered by that petition. It was a house of legal cards that was built on the shifting sands of Mrs. Edelman's testimony at trial, wherein she stated initially she had no concept of advance directives, and then upon being confronted acknowledged that she knew about the trust. She knew that she was acting, albeit not lawfully, under a designation of healthcare surrogate from her brother, who was attorney in fact, and that attorney in fact document did grant healthcare authority to the attorney in fact. And she was aware that there was a trust. The record is replete with testimony of the appellant indicating that, in fact, she knew that she had previously been a co-trustee on the trust. So for the appellant to look at the Court and say that she had no knowledge as to the advance directives or their import and attempt ultimately to place that blame upon counsel Fowler White is the trial court judge said Mrs. Edelman went to Fowler White to learn the law. Fowler White didn't teach her the facts, and that if she had any question as to what the advance directive instruments were, she should have challenged them pursuant to a DEC action. And the Court did find in her order on the entitlement to fees that, in fact, that Priscilla Edelman did not withdraw her petition for incapacity, nor did she amend her petition after being confronted with the fact that these advance directives were in place. Had Priscilla Edelman amended the advance petition, it would have been fatal to her ultimate plan of attempting to wrest control of her mother's trust from her. The issue of bed space is letting the tail wag the dog, Your Honors, because as you aptly noted, Bloomer Boardman was not removed from the state. She was not placed in a situation that was inconvenient to Priscilla Edelman. The appellant simply didn't like it because she felt she chose a better place for her mother. And once her authority was not acknowledged and the durable power of attorney power was exercised, and Burton Boardman ultimately decided to place her mother in a location for religious reasons, it was at that moment that the appellant initiated the petition. Now, the trial record indicates that...
But why is that so wrong? And why is that evidence of bad faith? She, for whatever reason, felt strongly she had a better place for her mother, for whatever reason.
Certainly.
And I only can assume that her reasons are based on good faith because I have no information to the contrary. So That being said, once for the first time that she has a conflict with her brother about the treatment of her mother, she decides to attack the power of attorney. Why is that necessarily bad faith? That's the first time she had a reason to say, wait a minute, what's going on here? I'm being now, my best interests for my mother are being frustrated by this document that was put in place 6 years ago, and now I have reason to question whether it was put in place correctly or rightfully, or whether she had the capacity to do it. Why is that necessarily bad faith?
Thank you, Your Honor, for that question. First, I must respectfully disagree with you. You have ample evidence in front of you that that was not actually Priscilla Edelman's motive. And that's what the trial court found, is that Priscilla Edelman's motive was to wrest control from her brother of her mother's trust. But to answer your second question, Your Honor, it is not an issue of good faith whether Priscilla Edelman wanted her mother to be in a different nursing home. That's not the issue before the court. While that's the attempt that the appellant has made to recast what she's done, in reality the issue before the court is that the appellant filed a petition which was false, which she knew was false, and even if she equivocated as to her knowledge of its falsity, she failed to correct it and propounded this evidence.
She filed a petition to establish a guardianship because she had come to the position that the power of attorney was wrongfully entered into because her mother lacked capacity at the time she entered into it.
I would agree with
I'm
that.
oversimplifying a huge case, obviously, but isn't that in essence what her position is?
Absolutely not, Your Honor. I would agree with that if she had added the advanced directive instruments to the petition, if she had not affirmatively stated that they did not exist.
Well, no, didn't she say that there, and just correct me if I'm wrong, but I thought what she said in the petition is that there were no adequate alternatives to guardianship.
Yes.
Was that the language?
The language is there were no,
Petition?
similar to that. I will agree that
Because
that's
that's the language in the statute that allows you to challenge documents that are proffered as an alternative to guardianship. And it says if the court, you file the affidavit that says you have a good faith belief that the documents aren't valid, and if the court finds that you have this good faith belief, then it cannot consider those advanced directives as an alternative to guardianship. It's as if they don't exist. Isn't that correct?
Yes, ma'am. However, it's difficult to claim that she did not believe that those advanced directive instruments were valid when she acted pursuant to them for 6 years and, in fact, sought for their modification in 2001, 6 years after the date that she also, in good faith, alleged that her mother lacked capacity to sign documents. Mrs. Edelman's good faith changed by the moment and was a moving target. And in this instance, Mrs. Edelman sought that Fourth Amendment to the trust to revert an interest in a trust back to her own benefit, away from her children, initiated, instigated, and caused that Fourth Amendment to the trust to be signed by Bluma Boardman. At the same time, she's testifying that she knew her mother lacked capacity. In addition, she signed a jurat in November of 2000, which she stated as the signer of the jurat that her mother was of sound mind to sign a living will. So for Mrs. Edelman to state that my action should be ignored and you should believe my testimony today that I knew all along my mother had no capacity to sign these documents is inconsistent with the facts which were presented to the court. In addition, the court found that there was bad faith in the affidavit, but then looked to other instances of bad faith which Mrs. Edelman demonstrated throughout the trial, including the affidavit which was shown to be untrue, including propounding expert testimony of an expert who had never even examined the witness or her medical records in full. And so the court listed a number, in fact, on 7 different occasions in her order, the court found that Priscilla Edelman applied the correct standard, that the petition was filed in bad faith, and then listed specific instances where Priscilla Edelman had actual knowledge of the advanced directives. At the time, she indicated there were no less restrictive alternatives. She proactively said that. She did not say there were less restrictive alternatives, which we challenge. She indicated that there were none. And from that perspective, it was the respondent, Burton Boardman, on behalf of his mother, who filed the advanced directives, which then prompted Mrs. Edelman to say, oh, I knew about those, but I don't think they're valid, even though I acted under them for years and years. And so the court found that Mrs. Edelman, as appellant, would, as the petitioner in the underlying action, propounded over and over and over again this moving target in an attempt to wrest control over Mrs. Boardman's trust. But all of that, while important, the evidence, even if the court finds that the evidence is contradictory, the standard of review for a finding of bad faith is abuse of discretion. And where there is substantial competent evidence in the record to support the trial court's conclusion, the appellate court should not disturb that finding. We submit that the orders as written were highly detailed, very specific, and that reasonable men may differ, but that is not the standard upon which the court is held, the trial court is held. In this instance, the appellate court should not disturb the conclusions of the trial court, who sat through 8 days of trial, countless motions, countless hearings, and was able to observe that at all times, going back to the filing of the petition, Priscilla Edelman's actual motive was not where her mother slept or even her best interest of her mother, but was in fact an attempt to wrest control of her mother away from her brother, that there was a great deal of animus to be shown, and the court was unequivocal that Priscilla Edelman wanted to gain control over her mother's inter vivos trust at a time that her mother was still alive, and that was an improper vehicle to do so. So, Your Honor, if Mrs. Edelman had stuck to the issue of housing and not brought in all these other ancillary issues, perhaps we would be talking about a different animal. But we are talking about...
There would have been a remedy for that.
Exactly. There would have been a quick remedy.
Whether it was in the guise of an incapacity or something else, there would have been a remedy for placement under the guise of the documents, or the documents being invalid and let's do something else, but somewhere that should have been disclosed in the initial pleadings.
No question, Your Honor.
Was the court wrong in saying that Ms. Edelman took her mother to the lawyer in 2004 for the Fourth Amendment or modification of her trust?
The test...
Was that factual misspeak somehow?
I don't know that it's a factual misspeak, because there was an improper conclusion that the court came to. And here's why. There were a number of witnesses who testified that at one time, Ralph Friedland, who was the attorney who drafted the advance directive instruments, actually went to Menorah Manor and met with the proposed ward, and that she was oriented as to person, place, and time, that she was appropriately dressed, that Bluma Boardman initiated the meeting by telephone calls, and that was corroborated by the drafting attorney's secretary. There was also testimony that at some point a document was brought to Bluma Boardman and she signed it at Menorah Manor, and that was done by Bluma Boardman's son, who had power of attorney and was properly notarized. There was some confusion as to what documents were signed where. I don't know to this day, I certainly wasn't there, but I can't even tell you what I think happened, because the testimony amongst the principals regarding which documents were signed when was contradictory, with the exception of the testimony of when Mr. Friedland actually went after the death of Bluma Boardman's husband to Menorah Manor and had the durable power of attorney, when Mrs. Boardman relinquished her control as trustee and appointed her son as successor trustee. That testimony was unequivocal. Subsequent to that, other documents were signed at other times, and it was not crystal clear as to what happened on what day.
All right.
The standard of review in the granting of denial of the motion for rehearing, which the appellant did not have an opportunity to discuss, is also abuse of discretion. And in this instance, as the court has noted, there was a 4-hour hearing which was held, which was not transcribed, wherein the court found, pursuant to the appellant's request for rehearing, that the appellant had ample opportunity to present evidence and declined to do so. And that was for obvious reasons. The appellant did not want to be forced to take this stand and be confronted on these issues of bad faith, wherein her initial pleadings did not contain truthful statements regarding advance directives.
Well, the reality is, we will never know what happened at that hearing.
Absolutely, and therefore the court must rely upon the judgment of the trial court, which indicated that the appellant had ample opportunity to present evidence. Keep in mind, too, that the appellant then, without leave of court, filed an affidavit protesting her innocence and claiming that it was her attorney's fault that she filed this petition and was uninformed as to what the advance directives were. And Judge Laughlin did not accept that argument. She did not accept that argument as an excuse for the reason to wholly omit and wipe clean the slate and act as if there were not advance directives in place. Finally, I'd like to briefly address the Stockman argument, which was raised by the appellant regarding the failure to plead attorney's fees. And the Stockman argument is inapplicable in this case, and it also was waived. I would like to first address the waiver issue in that the first time that Stockman was raised as in defense of the assessment of attorney's fees was over 6 months after the order granting entitlement to fees was issued. Not only was it not raised prior to the hearing, not only was it not raised at the hearing, not only was it not raised after the hearing, but after the court issued its order and after the petitioner had filed other motions, only then did it occur to petitioner to raise a Stockman claim. And so it is forever time barred from being considered by the court today. In addition, not only is Stockman but not only was Stockman waived, but Stockman is inapplicable because the court could not make a determinant of bad faith until all of the evidence was collected. And in this instance, no entitlement to fees or costs could be pledged alleging bad faith until that petition for incapacity had been dismissed. The trial court found, quote, "There is no requirement to plead entitlement to fees and costs until the trial of the petition to determine capacity and the assessment of the necessity of the appointment of guardian has been made by the court." And the court leaned on the Gans case, Gans v. HZJ case, for that conclusion. Finally, this court will note that the guardianship documents, in order to initiate a petition for incapacity and initiate a petition for guardianship, which are somewhat symbiotic, although you must initiate the petition for incapacity first, and that must be determined before the necessity of guardianship must be addressed. Neither of them contain an opportunity to plead for attorney's fees. And so in following within the probate rules, there is not, on behalf of the respondent in this instance, an opportunity to plead for fees because there is not a typical answer. There is not a pleading responsive to a petition for incapacity and a petition for guardianship. And so from that perspective, the respondent is in the position of only knowing when bad faith occurs when the court finds that there was no basis for the petition for incapacity because of the advance directives and therefore a guardianship isn't needed, and only then does bad faith become evident. And so from that perspective, we believe that Stockman is inapplicable and that the respondent, in this case the appellee, was appropriate in seeking attorney's fees timely upon a ruling by the court dismissing the petition for incapacity.
Can I ask you one question? I think you still have a minute to answer.
Yes, sir.
What should we make of the portions of the court order lamenting generically the problems with guardianships and people dismantling all these best laid plans and this being a blood sport? And how does that fit in the context of the court's specific findings, these generic findings? Are they relevant to this case, or are they just stream of consciousness?
I appreciate the opportunity to weigh in on that.
Figure out, because I sat in guardianship as a trial judge, and I never said that stuff in an order, but I'm not saying there's anything wrong with it. I'm not saying it's not true. I'm just wondering why it found its way into this case.
It is my opinion, for what little that is worth, that because this was so contentious and the court was so offended by the ongoing mendacity of the petitioner, that she felt that this action became a blood sport, and that my client
But
is...
she didn't really say it.
I agree that I wish she had...
Written in the passive voice, and I'm thinking, just say it if that's what you meant. Was there something else said at the hearing that makes, we can tie this into this case?
At which hearing? At the hearing on attorney's fees? On entitlement to
The ones
fees?
that are transcribed, any of them.
Okay.
Okay.
There were certainly...
I mean, if you don't know, I'm not
I
going to
do.
pin you down. Okay.
I appreciate the
One of
opportunity
the
to
8
respond.
hearings over 2 years, I think he's talking
Yes, sir.
about.
And unfortunately for everyone, I'm sure, I was counsel for respondent for all of them, so I can answer that with specificity. I can tell the court that petitioner in that action brought in my client's ex-wife to testify as to his infidelity, brought in a son against whom he was estranged.
This is a blood sport.
Yes, sir. A son from whom he is estranged and has not spoken, who took the stand simply to spew vitriol at his father. In my own, I have to accept responsibility. We brought a letter into the court which demonstrated what we felt was an attempt to influence a witness.
I didn't mean to get you off. I can see you're emotionally involved. You don't know the answer, but I was looking for a yes or no type answer. I'm not
sorry.
going to keep score of the 50 things that you might just tell us.
Sure, that I could have done better.
So
Sure.
I mean, it was kind of yes. It wasn't just stream of conscience. I've been a probate judge for 20 years, and here's what I want to say in general. And it really was pertaining to this case.
If I may be so bold, Your Honor, it was appropriate to
Okay.
this
All
case.
right, that's my question, thank you.
And so it is our position that the standard of review applicable to this instance is abuse of discretion for both the right to rehearing and for the imposition of attorney's fees for bad faith. And because the court did not abuse its discretion in either of those instances, and because Stockman does not apply, we ask the court to deny appellant's request that the matter be overturned. In addition, we seek our attorney's fees as we believe that this incident is yet another chapter in the events which occurred initiated by the appellant's bad faith filing of her petition. Thank you, Your Honor.
Thank you.
"15 minutes went by very quickly, and I'm going to have to ask, I can see right now that you revisit our briefs on a lot of these subjects. Because I never, in the first 15 minutes, really got to the main point, and that is that the attorney fees awarded here were obviously awarded for the blood sport or the affidavit, not because the petition was filed in bad faith. If the person is found to be incapacitated incident to that petition, then it is a petition that's filed in good faith. What happened was the trial court got off on the attack on the DPOA, and that does not cover, the statute does not allow for any attorney fees, even if the affidavit was bad faith, and we say it was good faith because everybody testified about the incident of the DPOA, all the family, Dr. Sergey, Dr. Edelman. And so there was a reasonable basis for the affidavit, but the court got off on that and awarded fees for the blood sport, for the multiple collateral arguments she mentioned in her order. You don't get fees if the petition's filed in good faith, and if the person is incapacitated, that's good faith. Not only that, there's no doubt but that the original intent or good faith had to do with placement. You know, whether it's Hillsborough or Tampa or whatever, but what she had in mind was to be able to better care for her mother. There was no other reason to do that. And then, yes, along the way, whatever may have happened along the way doesn't give rise to attorney fees under this statute. None of the other statutes for guardianship, for having to do with the affidavit itself, none of those provide for attorney fees, only if the petition is filed in bad faith. These cases had to do with people who are sought to be declared incompetent when they're not. And that's why the legislatures put that in there. And I ask you to revisit our brief on that for more detail. And I don't know why the appellee, but beginning with the judge, said that there was an attack. There's nothing in the record to show an attack on any trust or testamentary plan. Nothing. The affidavit that was filed 2 months after the original pleadings only singled out the DPOA, and the reason for that is that's what Burton Boardman was using for placement, to change the placement. There was never any allegation made having to do with the trust or any, I don't even have any idea where the judge came up with that. We recited everything that happened in the record in our brief, and there's nothing in there that has anything to do. It was all about the DPOA. That's the only thing that was tried, and placement. There was nothing about any trust. And appellees want to talk about discretion with good reason. I understand that.
Well, I mean, let me just understand one thing. The durable family power of attorney was in 01. The trust was amended up through 04.
The last amendment, the Fourth Amendment, was actually executed 8 months after the execution of the DPOA.
So
that's what got the trial judge
So I'm
excited.
just trying to think like the judge, because obviously that's what we got here. The judge is thinking that the durable family power of attorney predated the trust, and the attack on the power of attorney, that the woman's incapacity when the power of attorney made would invalidate the power of attorney. Is that correct?
No, the trial court said that this was an attack on the testamentary plan, and the attempt to
Well, I mean,
gain.
everything that flowed after the power of
And-
attorney
and-
was part of the testamentary plan, but it all started with the power of attorney in 2001.
No, the trust predated that. What happened after the power of attorney was just an amendment to the trust.
Okay.
There was never any attack on any aspect of the trust. The affidavit that was filed was strictly based on the invalidity of the DPOA. And, you know, they talk about discretion, but we cited one case, and I think it's applicable here. There's no discretion to misapply the statute. Obviously, something happened along the way. Maybe there was blood sport. Maybe it was the lawyers. I don't know what it was, but the multiple.
But I mean, the trust is one of the alternative segments to the guardianship, to the lack of a necessity for a guardianship proceeding. That was one of the reasonable alternatives.
Yes, but it had nothing to do with what was tried. And the trust.
The issue was the placement.
Right,
But it was
the trust was the money part. And there was no attack on the money part. We were talking about the person. That was Priscilla Edelman's interest, was placement of the person. That's how it all started. And it was started in good faith. The lawyers prepared these things. It was
Sir?
all of this was new, and the law,
The
they
end of
did
your
it, and thank you.
Thank you. That concludes our docket for today. Court is adjourned.